So we move forward to our next session on appeals, penalties, and prosecution. As told by Dr. Patel, due to the last minute change in his traveling schedule, Mr. Pramod Kumar will not be able to join the session. We would like to welcome Mr. Gaurav Jain, a practicing advocate and chartered accountant, to take over. Mr. Jain has over 17 years of experience specializing in handling direct tax litigation before the tribunal and high courts. A very warm welcome, sir.
Thank you, Ridhima. I hope I'm audible.
Yes, sir.
Okay. Thank you, Ridhima. So, yes, friends, the topic that has been given to me today is surrounding appeals and dispute resolutions and related penalty prosecution amendments proposed in the budget 2022. Friends, litigation is an important fora of the Income Tax Act, and wherever the returns are selected for scrutiny, they are subject to litigation, and we know that the litigation goes for many years, and therefore it constitutes an important aspect of the Income Tax Act. Not much of amendments have been made with respect to appeal provisions, but yes, certain significant amendments have been made. First, friends, if you will recollect, in 2021 budget, it was proposed that akin to faceless assessment procedures for assessment as well as CIT appeal, a faceless mechanism of appeal was also recommended for ITAT. And presently, the transfer pricing proceedings and DRP proceedings are also not faceless. They are virtual, but not faceless. So it was proposed that all these three forums, that is TP proceedings, DRP, and tribunal, will also be converted into faceless mechanism, and modalities thereof were to be pronounced, and the deadline for the same was announced as 31st March 23. So considering a lot of time has lapsed and there are certain technological changes which are still being within the domain of the tax department, the deadline, originally deadline of 31st March 23 has been deferred to 31st March 24, and therefore all these three proceedings for now will continue in their existing avatar only, that is not faceless, but possibly either virtual or physical in TP, DRP, and including before the tribunal. So that is insofar as appeals before DRP, transfer pricing officer, and ITAT is concerned. The second and the most important amendment that has been proposed in budget 2022 is the provisions relating to avoidance of repetitive appeals before the High Courts and Supreme Court. Friends, we had an existing provision in terms of section 158A and 158AA of the Act, which provides for dissuasion of repetitive appeals before ITAT, High Court, or Supreme Court. 158A dealt with appeals where assessee wants to defer adjudication of matters pending before higher forums. Then the assessee can suo motu recommend deference of that appeal. So for instance, if an issue in the assessee's own case is pending before either High Court or Supreme Court, then the assessee can suo motu refer that matter to the commissioner and say that that I can undertake that whatever be the decision of the High Court and Supreme Court in my matter on the issue involved in the earlier years, that can be applied in the appeal for the present year. And for that reason, on the basis of that undertaking, the assessee need not file an appeal before ITAT, High Court, or Supreme Court, and give an undertaking that whenever that decision will come, that can be followed in the present appeal, and therefore that decision can be deferred. And as and when the decision of an earlier year comes, that can be followed in that matter. Similarly, the provision was available to the revenue also, that in case the issue is pending before higher forum, that is High Court or Supreme Court, then revenue can also follow that decision in a particular year. But the existing provisions only restricted followance of that decision only when the matter was pending in the assessee's own case. So for instance, if an issue is recurring in my own case year after year, either assessee in terms of 158A or revenue in terms of 158AA can initiate the process of entering into an undertaking to say that my decision in the earlier year will be followed in the subsequent year, and I need not file an appeal in the subsequent year. So although these provisions were there, but these are not practically very much initiated or taken up either by the assessee or revenue. But in continuation of that, in order to expand the scope of the existing provisions, a new provision is proposed to be inserted, that is section 158 AB, where the scope is expanded in the sense that in the present provisions, the scope is restricted to only the issue pending in the assessee's own case. Now that issue has been expanded, that if a common question of law is involved in any other assessee's case also, so the revenue can enter into an undertaking with the assessee that whenever that decision will come in case of any other assessee, that decision can be followed in the assessee's case, and on the basis of that undertaking, the revenue is not required to file any appeal. The only difference is that this provision is only applicable for revenue and not for the assessee. So in case assessee wants to apply a decision or question of law pending in any other case, then assessee is not given an option to enter into an undertaking. It is only the revenue who can enter into this undertaking and can decide whether or not to file an appeal. The decision will be taken by collegium of commissioners. So a collegium possibly will be formed, which will comprise of 2 or more chief commissioners or principal commissioners, who will take a decision that wherever an issue is pending before High Court or Supreme Court, they will apply. They will go to the assessees. They will take consent from the assessees that since the common question of law is involved in other cases, we undertake to follow that question in your case, and therefore on the basis of that undertaking or consent from the assessee, the revenue can defer filing of appeal on that issue. So, but this provision is applicable, as I said, only when the appeal is to be filed by revenue. One, the question of law must be pending only before the High Court and Supreme Court. So if the question of law is pending before ITAT, for instance, if a question has been framed and that has been referred for answer by a special bench of a tribunal, that will not be within the purview of new provision. Only when the question of law is pending before High Court or Supreme Court, that the new provision can be applied. Then, as I pointed out, the new provision is not restricted to question of law in case of assessee only, but in any other case also, if a question of law is involved, that can be applied to defer the filing of appeal in the new provision. And then authority before which filing of repetitive appeal can be avoided is only ITAT or High Court. So if an appeal is to be filed against an assessment order before CIT appeal, this provision will not come to the rescue. An appeal will be filed before the CIT appeal. And this is for the reason that before CIT appeal, revenue is not allowed to file an appeal. It is only the assessee who can file an appeal before the CIT appeal. So it is only when an appeal is to be filed from CIT appeal to ITAT, and that too by the revenue, that this new provision can be triggered in. So post this amendment, the old provision of section 158 AA will stand repealed, and it is only the 2 provisions that will remain in the statute, that is 158A, which provides power to the assessee to defer filing of appeal before ITAT, High Court or Supreme Court. But this is only when the question of law is involved in assessee's own case and not otherwise. And the second provision that will remain in the statute is 158AB, that is the new provision where revenue has been given the power to defer filing of appeals subject to consent of assessee when question of law is involved in assessee's own case or in any other case. So this is a welcome move. This is an important amendment which has been made in this budget. But the question that would still remain is what would be the effectiveness of this new provision. As we have seen in the earlier provisions 158A and 158A, and friends, I have been in this practice of litigation since past many years. I would have found in 1 out of 100 cases only that these provisions have been resorted to either by the assessee or by the department. There is some sort of hitch both on the side of assessee as well as the department to enter into this undertaking. I personally took up one of the matters where I approached department to give me an undertaking to avoid filing of appeal in a matter before High Court, but I could not see that undertaking in any real time. So I am not too sure how effective these provisions will be, but certainly it's a welcome move. And if the revenue takes it up seriously, then we can avoid many unwanted litigation where revenue files appeal and we have to just go and tag ourselves in the High Court or in the Supreme Court to await decision on a question of law pending in a matter in a different case. So it's a welcome move, provided department takes it up seriously and do not file repetitive appeals before the High Court or Supreme Court. So friends, was the first amendment. The second amendment is in section 245 MA. This was also a new provision which was introduced in the last budget in the year 2021. Friends, if you would recall, the section 245 MA was introduced to introduce a new provision of dispute resolution committee. That is where the issues involved are small. That is where the assessee has filed appeal and his return total income is less than 50 lakhs and the tax involved in assessment is less than 10 lakhs. Then akin to the provisions of dispute resolution panel, a new provision of resolution of that dispute was given to a new committee called a dispute resolution committee, which was also a collegium of commissioners who can decide and fast track disposal of the appeals involving small issues. So that provision was introduced, but the lacuna in that provision remained how to give effect to the directions of the dispute resolution committee. So that provision was not there. So in case a matter was referred to DRC and they had taken a decision, then what is the time limit with which the assessing officer will give effect to the directions or orders of DRC, and whether or not he has power to give effect to the orders of DRC was a gray area, was not there. So in order to remove that anomaly, section 245 MA has been amended to insert a new subsection 2 therein to provide power to the assessing officer to pass an order giving effect to the order or direction of the DRC within 1 month from the end of the month in which the order is received. So this is also a welcome move. This is sort of a clarification, a lacuna, an anomaly that remained in the provisions of section 245 MA, which has been corrected, and a welcome move. Third, friends, is an important amendment in section 263 of the Act. And this relates to transfer pricing orders. Now, friends, what was happening that when a transfer pricing officer passes an order, then that is mandatory for the assessing officer to be adopted in the final assessment order, and assessing officer has to pass order in conformity with the arm's length price adjustments proposed by the transfer pricing officer in the transfer pricing order. And then the final assessment order is passed, which can be further appealed either before the CIT appeal or the tribunal in case there is an adverse adjustment. Now, 263 of the Act, which provides power to the commissioner to revise an assessment order, the issue arose whether commissioner has power to propose revision with respect to adjustment proposed in the transfer pricing order. Ordinarily, the plea of the revenue is that since it is mandatory for the assessing officer to comply with the directions suggested by TPO, it automatically merges in the assessment order, and it is the assessment order only which is available with the assessing officer. And therefore, when the TPO order merges with the assessment order, this commissioner has power to revise the assessment order, which would include adjustment proposed in the TPO order only. However, there were series of decisions which suggested that the administrative officer over the TPO is not the normal principal commissioner, but the DIT TP. That is the commissioner involved in the transfer pricing jurisdiction. And therefore, the normal commissioner who has the power to revise assessment order do not have power to revise the TP order. So there was jurisprudence to that effect. There were certain decisions where the 263 orders proposing adjustment in the TP order were quashed on the ground that TP orders are not within the purview of CIT under section 263 of the Act. Now, in order to set that at naught, the amendment has been proposed in section 263 to include transfer pricing orders also. So with the proposed amendment, now 263 has been, now in section 263, commissioner has been given power to revise both the assessment order as also the transfer pricing order. So with this, the present debate whether the CIT has the power to revise TP order or not has been taken away with, and it has been categorically provided that the commissioner can revise the TP order itself, and all the consequential amendments have been made in section 263. So the major amendment is that TP order has been included in section 263 of the Act. So this is second and third most important amendment which needs to be kept in mind. Now, fourth amendment that I'm dealing is in relation to an insertion of new provision, that is 239A of the Act. Now, what is 248? Friends will recall that where the issue relates to TDS TDS with respect to international transactions, that is TDS under section 190 of the Act. Now, if the assessee, and in most of the international transactions, tax has to be borne by the payer as per the agreement between the payer and the payee. Now, in such a situation, if the assessee bears the tax and he feels that ultimately tax was not to be deducted at source, then he was given a power to file an appeal before Commissioner Appeals under section 248 of the Act. Now, ordinarily, this would happen in a situation that assessee himself, because there was an ambiguity, deposits the tax, and if he considers that this tax was not to be deducted, he can file an appeal before Commissioner Appeals. So there were two situations. One, where the assessee suo moto deposits the tax, he can file an appeal before Commissioner Appeals. Or let us say he files an application under section 195(2) for applying for either lower rate of deduction of tax at source or at nil deduction of tax at source, but that application is not entertained or is rejected. Against that order, the assessee could have filed appeal before Commissioner Appeals under section 248 of the Act. But the condition precedent for filing the appeal is that the disputed amount of tax was to be deposited beforehand, and once that tax is deposited, appeal can be filed within 30 days. Now, in the first situation where the assessee suo moto deposits the tax, there is no application before the assessing officer. So there is no adjudication by the assessing officer in that situation. So in order to align the existing provision, it has now this section 248 has been omitted. A new section has been inserted, that is section 239A of the Act, which provides that the assessee would have to first willy-nilly automatically approach to the assessing officer to decide whether or not the assessee was required to deduct and deposit, bear and deposit that tax. Once the assessing officer adjudicates upon that application either in favor or against the assessee, if the application is decided against the assessee, against that application, the assessee can now file an appeal under section 246A of the Act before the Commissioner Appeals only. So 248 has been removed, and the procedure of adjudication on this tax deduction of tax at source has been embedded in section 246A only. So basically, a new provision relating to filing of an application under section 239A has been brought in. So AO will decide whether or not this transaction was subject to TDS or not. In case he decides adverse, now this new provision has been included in section 246A, and an appeal can be filed before the CIT appeal. So this is an amendment, but still the requirement of deposition of the disputed tax still remains. The application can be filed only if the tax was deposited earlier. Once the tax is deposited, the application can be filed, and against the decision of this application, an appeal can be filed under section 246A of the Act. So this, friends, can be kept in mind. According to me, there was no requirement for this amendment, but still the revenue has in wisdom amended the existing provision and brought all the provisions of appeal under section 246A. So possibly in order to avoid confusion of filing appeal either under section 248A and not under 246A, possibly to avoid that anomaly or confusion that can rest in the minds of the assessees, this new provision has been inserted, which provides for filing appeal under one single provision of 246A only. So this is the fourth amendment insofar as appeals are concerned. So there are not more amendments in this budget with respect to appeals. And as we see that not much of amendments have been made, most of the amendments are on the administrative side. Wherever there were anomalies or rationalizations were required, the amendments have been made in the budget. Otherwise, the provisions of the statute have been maintained consistency in most of the provisions in this budget of 2022. With this, I move to now penalty and prosecution provisions. Not
Sir, before you move on to the next penalty part, there's a question from one of our listener,
sure.
Niharika. So she has a question that when a case is pending with High Court and Supreme Court, is revision possible?
Revision? Can she clarify the query? Revision with respect to?
Revision with respect to, I think, section 263 she's asking.
No, in the subsequent year. So when that issue is pending before the High Court and Supreme Court, on that issue, the revision is not possible. But certainly on other issues which are not pending before High Court and Supreme Court, 263, revision under section 263 is possible. This is for the reason that since that issue has already been adjudicated by the lower forum, that is either the CIT appeal or ITAT, that issue stands merged with the order of CIT appeal or with the order of ITAT. And when the issue is merged with the order of CIT appeal, the powers of CIT cannot be exercised on that issue, and that embargo is there in section 263 itself. So insofar as that issue is concerned, 263 revision is not possible. But on other issues which are not pending before High Court or Supreme Court, certainly CIT has power to revise the order, provided time limit is available for revision of that order.
Thank you, sir. Sir, one more thing, I'll request you to share your PPT and slides so that it can be an easy track for the attendees also.
Sure.
So you can do it on a slideshow mode, it would be easy.
Can you see this?
Yes, sir.
So any other question, or should I start with my penalty part?
I think for now you can. Thank you.
Yes. So friends, next amendment, as I pointed out, no new penalty provisions or not substantive amendments have been made in penalty prosecution provision. Most of the amendments are in the nature of rationalization of existing provisions, or wherever there was a lacuna or some gap that remained in the earlier amendment that have been sought to be filled up with the proposed amendments in this budget. The first amendment is in section 271 AB, AC, and AD of the Act. These penalty provisions are with respect to penalties that can be imposed in case of search assessments, that is wherever an undisclosed income is assessed in case of 153A, 153C, and now going forward under 148A of the Act, or unexplained cash credits on unexplained expenditures under section 69ABC of the Act, or falsification of books of account. Now, under the existing provisions, this penalty can be imposed only if the assessing officer is satisfied that the relevant default warrants imposition of penalty under the aforesaid provisions. In most of the other penal provisions of the Act, like 270A, 271, 271A of the Act, this power has been given to Commissioner Appeals also. And the reason for giving power to Commissioner Appeals is that at times the assessment order, wherein the relevant default was deducted, is subsequently modified in the appellate proceedings before the Commissioner Appeals. Either the assessment order is modified, or the relevant adjustment is modified, or it is enhanced. So in those situations, when the CIT appeal takes a view different from the view taken by the assessing officer on the relevant default of undisclosed income, unexplained credits, unexplained expenditure, then it is not the assessing officer who can impose the penalty, because it is not he who has detected that default. It is the CIT appeal who has detected that default, or he has modified the rationale or basis of that default. So in those situations, it is not the assessing officer who can impose the penalty on these defaults, but the relevant officer would have been Commissioner Appeals. Now, in the absence of Commissioner Appeals being given power in these provisions, it was not possible for imposition of penalty if the original default was modified or enhanced by the Commissioner Appeals. So there was a gap in that sense in these provisions. So in order to fill that gap, now Commissioner Appeals has also been given the power to impose penalty in the aforesaid provisions. So under the amended provisions, akin to other sections like 270A, 271, etc., Commissioner Appeals has also been given the power to impose the penalties. So this is the amendment in sections 271 AB, AC, AD of the Act. And the reason for the amendment, as I've explained, is when the assessment order is modified, then it is the Commissioner Appeals who could have imposed the penalty. So in order to give him that power, now Commissioner of Appeals has been included in the said sections. Now the second amendment is 276 AB. Friends, it is the only rationalization of the provision. You would recall there used to be a provision in 269 UC to UD of the Act, which provide that where the assessee transferred immovable property at a price less than what in the view of the central government should have been the appropriate market price, the central government was given the power to acquire that property. So that provision used to exist until 2002, which was abolished, and there was no and pursuant to abolition, central government did not have power to acquire the property where the transaction, the price for transaction was less than the market rate. However, the penal provision for entering into such transaction was contained in 276 AB, which still continues in the Act. The reason for existence of that penal provision is that those disputes which may be hanging in either tribunal, high court, or Supreme Court, once they settle, these penalty provisions could have been invoked. So for that reason, while the substantive provisions of 269 UA to UD were removed, but penal provisions were continued in the Act in order to impose penalty on the issues which were pending in litigation. However, since 20 decades, 2 decades have already been passed since the abolition of that provision in 2002, 16/2002. Now the amendment has been made that these provisions will not be attracted after 1/4/2022. That is, the penalty under this section will not be levied after 1/4/2022, because 2 decades have already passed. Whatever the issues will remain with respect to this provision would have already stand settled, and there would have been no occasion to initiate or impose penalty under this provision. So in order to remove one section from the statute, this provision has now been omitted, and it has been provided that this will not apply after 1/4/2022. So it's more of a rationalization of the prosecution penal provisions that this amendment has been made. Now, second amendment is made in section 276B and 271C. It's again more of a rationalization provision. Now, 276B and 271C relates to prosecution and penalty in case of defaults for tax deducted at source. Now, one of the defaults on which either penalty under the aforesaid section or prosecution under 276B could be imposed was failure to pay tax under second proviso to section 194B. 194B is, friends, where the tax is required to be borne when some present is given on winning of lottery. So in those situations, tax is borne by the payer who is distributing the winnings from the lottery. So it is only a rationalization provision. The section 276B and 271C referred that this penalty and prosecution could be imposed when there is a default in second proviso to section 194B, whereas there is no second proviso because of some amendment, and there is only one proviso in section 194B. So in order to rationalize these provisions with amendment in 194B, it is proposed that the word second used in section 276B and 271C will be removed, and it will only now refer as a default under proviso to section 194B. So this is only a rationalization provision in order to rationalize the penalty provisions in 276B and 271C with the amendment made in section 194B, where second proviso no longer exists and only one proviso is there, and therefore the new provisions will only refer to proviso to section 194B. So this is the only amendment insofar as these two provisions are concerned. Next amendment is in 278A and 278AA of the Act. These are prosecution provisions which for various defaults committed under the Act. So there are penal provisions and there are prosecution provisions. These are standard provisions where multiple defaults, when are committed under the Act, prosecution proceedings can be initiated under these two provisions. Now the default committed for non-deposition of tax collected at source under section 276BB of the Act was not included under these prosecution provisions. So section has been amended to include section 276BB to cover prosecution even in cases where there's a default in collection and deposition of TCS. So that is the only amendment in this provision. It is again a consequential amendment in order to complete the penal provisions on which prosecution can be initiated to include TCS default also. So this is the only amendment with respect to 278A and 278A is concerned. So these were the nominal amendments insofar as appeals and penal prosecution provisions are concerned. So considering not much amendments have been made, I am able to finish my session in a record time, and I therefore request the organizers to take the proceedings forward.
Thank you so much, sir. That was surely an insightful session. I would like to take a moment to see if anyone has a question from sir. Sir, I think this was all. Thank you so much.
Thank you. My pleasure. It was my pleasure to be part of this marathon.
Thank you, sir. Thanks a lot.
Thank you.